All right. Well, for time's sake, I'm going to get started. Hello, everyone. My name is Callie Chadwell. I'm the event manager at the WTIA. Thank you so much for joining us this morning. Before we get started, I just wanted to go over a few housekeeping notes. This event is being recorded, and there will be a Q&A portion at the end of the presentations today. We have that slotted for 11:10 to 12. So if you have questions throughout the day, you can post those in the Q&A box at the bottom of the screen, and we will get to those at the end of the presentations. Or if you would like to ask your question live, you can use the raise hand function during the Q&A, and we will pull you up on stage so you are able to ask your question. So with that, I'm going to kick it over to Ari Yu, Chair of the WTIA Cascadia Blockchain Council, and she's going to get us started.
Thank you, Kelly. And thank you to everyone that's taking time out of your day today to join us for this very important WTIA and DFI, Department of Financial Institutions, Town Hall. I'd also like to say thank you to our regulators, the DFI folks that are with us today, because it really means so much to us as the community to build and grow our relationships so that we can really work together to build a greater region for this innovative technology. Cindy Fazio, Faith Anderson, Roberta Hollingshead, Charlie Clark, Drew Boutin, just have been really enjoying getting to know you more over the past several months, and look forward to growing our relationships as we move forward. And to the community, I know that we are building, we're investing, and we really see the opportunity in this space. And so that's why we're all here trying to make a difference and make our dents in the world. And as many of you know, there's been a lot of talk in the community, especially over the past couple of years, about what's going on with Washington State. You know, what can we do to be better? You know, where's everybody? How do we build? How do we make this easier? And really, at the end of the day, we have to realize that innovators are going to be pushing boundaries. We're building and trying out new things and new technologies. Investors are going to be making bets, educated bets in the space with their dollars. And that's very important to the space. But we also have an important part of the community, which are the regulators. You know, they're here to help us stay safe, help us make sure that the playing field is even and fair, and that we can build together. And so, you know, I think a lot of us choose Washington State and this Cascadia region because it really is one of the best regions in the world. I mean, not only do we have mountains and oceans and water and all of this nature, but this is the home of Microsoft and Amazon and these great innovators that have really made a huge impact, not just locally, but also globally. And so, you know, this is the capital of cloud computing, of platforms, of data innovation. And it only makes sense that this region specifically rises to the top to lead not just the United States, but the world in this innovative technology. And I think most of us here in this room recognize that blockchain specifically is one of the greatest innovations of human history. I know a lot of people will think that this is me kind of overreaching, but I truly believe this. You know, compared to the antibiotics, which, you know, really helped humanity, I really believe that blockchain technology will also help humanity in that way, because we do really need more trustless systems, and we need to make it easier for people to connect and interact and transact. And then final closing thoughts are, I'd like for us to really take opportunity to build this public and private partnership and relationship. we all want the same thing, which is a really thriving economy where people are able to build and innovate and invest and do great things for humanity and the citizens of our communities, but in a safe way. And so I hope that our conversations today are just the beginning, where we can come together regularly, build relationships. As an innovator, I think I look to the lean startup often, right? Where as an innovator, I'm taught to go out and talk to my customers, especially in the beginning of a entrepreneurial journey, to get to know my customers, figure out their pain points and their problems, and figure out what their day in, day out looks like. And I see ourselves, the community here, as those customers of the DFI. And so, over the past several meetings, I've learned that the DFI really does want to have an open conversation and be readily accessible to the community, which is great because the community wants to access the regulators and ask questions and build those relationships. And so I hope today is just the beginning of that, and we can build together and make this one of the best places to innovate, to invest, and to just lead the world in this innovation. Thank you to all of our sponsors. Thank you to the WTIA, and thank you to our community and the DFI for showing up today. Really, really appreciate it. And with that, I'm going to hand over the microphone to Charlie Clark, the director of the DFI. Thank you so much for joining us, Charlie.
You're welcome, Mary, and thank you for those great comments. I couldn't agree more. And good morning, everyone, and thank you for joining us today. As Ari mentioned, I'm Charlie Clark. I'm the director of the Washington State Department of Financial Institutions. And I want to begin with thanking the Washington Technology Industry Association for hosting this virtual event. I also want to thank the WTIA for collaboration in planning today's meeting, and really for your efforts in candidly discussing the technology industry's thoughts around regulatory challenges and opportunities in Washington State. I'll begin with some background on DFI and fintech regulation. It's been at least since 2013 that we've had a group at DFI, a group of financial regulators dedicated to following developments in fintech. We've been very engaged in fintech business models as they've emerged, and we've been a leader in national regulatory associations. And I'll just give you some examples. Our current Securities Administrator, Bill Beatty, has served as the president of the North American Securities Administrators Association, or NASA, and has served on his board for years. I currently serve on the board and executive committee of the Conference of State Bank Supervisors, and have testified before Congress on behalf of CSBS as recently as 2019. Before the House Financial Services Committee's Task Force on Financial Technology. And Rick St. Onge, who oversees the examinations of our money transmitters, currently serves as the president of the Money Transmitters Regulators Association. And we've got examiners that have provided training to other regulators around the country in several areas related to cryptocurrency regulation. And so why do I share all of this participation and our involvement in national associations? It's because it's been critical to DFI's engagement through the years. And it's through this participation that we continue to improve the ability for fintechs to scale nationally. We continue to improve and make our examination process more efficient and supervision more efficient. We're reducing regulatory burden while also maintaining the highest level of consumer protection. It's that engagement at the national level that has been so critical, and I'll give you an example of how it's impacted action that the Washington DFI has taken. Back around 2017, we had years of meeting with crypto companies and fintech companies that were trying to get licensed as money transmitters around the country. And we heard the pain points in connection with that. They had to get a separate license in every state, with the exception of Montana, if they wanted to scale nationally. And there was just tremendous burden in connection with that, because they had to submit the same materials, often meet the same requirements to each separate state. And so I heard this, my team heard this. Here in Washington, we proposed a multi-state MSB licensing agreement where it would streamline this process. It would share work and reduce redundancies. It would speed up the time to get a license around the country in each separate state. And I'm happy to report that we kicked it off in 2018. We kind of pitched the idea to our fellow state regulators around the country. And today we have 29 states that have joined the agreement. So progress can be made by listening to industry and listening to what's going on around the country. I want to start off by focusing on money transmission. Today you'll hear from Cindy Fazio, who's our director of our Division of Consumer Services. Cindy oversees our regulation of non-depository money transmitters, consumer lenders and mortgage lenders, as well as several other non-depository financial industries. Cindy will talk about our history as cryptocurrency business models emerged. She'll give some history on how we were one of the first states to clarify our money transmitter law around cryptocurrency, so as to avoid just confusion that existed at the time around how to comply with a formerly antiquated statute that had never really contemplated Bitcoin or cryptocurrency. Today, I'm happy to say that we've licensed 61 companies as money transmitters that have crypto used somehow in their business model. So turning to securities, today you'll also hear from Faith Anderson, who's our Chief of Registration in our Securities Division. On the securities side, we have taken enforcement action against certain companies that have offered unregistered securities, generally involving initial coin offerings or tokens, where we've concluded that the particular offering involved an investment contract. We've also heard frustration from several of these companies and others that have experienced difficulty navigating the securities laws. Some have suggested that legal fees are an impediment to raising capital. So today we'll discuss some ways we're providing information concerning the application of securities law to cryptocurrency that will hopefully ease these burdens. Turning to the trust and banking side, we've been very open to allowing integration of new technology into our banks, credit unions, and trust companies. You'll hear from Roberta Hollingshead, the director of our Division of Banks. Roberta will discuss the state and federal landscape around custody of digital assets, including our work in the area of integrating custody of digital assets into our trust and banking statutes. I want to talk for a moment about open communication. And Ari mentioned just the absolute necessity for good communication in her opening remarks. I couldn't agree more. And I thought that we at DFI were doing pretty well. Since at least 2013, we've encouraged our staff to sit down with startups, talk about what they want to do, talk about what activities may require a license or a charter. We've also facilitated calls on an individual level, or we've brought in our counterparts in other states to have a multi-state call where companies could explain their plan, their product, or talk about how their business model was going to change. However, we can do more to support innovation in Washington. So today, DFI is announcing the launch of its Center for Fintech Information. Our Center for Fintech Information is staffed with experts from our Division of Consumer Services, our Securities Division, and our Division of Banks. We have a new dedicated webpage designed to be a one-stop location for information on fintech regulation in Washington. One common request from industry that I've heard has been that DFI should provide more guidance documents around fintech regulation. We've heard your requests, and I'm happy to report today that we're issuing 4 new guidance documents on topics including digital assets and securities law, virtual currency and money transmission laws. We're issuing a statement regarding banking and custody services for digital assets, and one on partnerships with depository financial institutions related to lending. Some services that our Center for Fintech Information will provide are, of course, providing information on doing business as a regulated entity. It will allow our employees to engage more with companies, with you, in reviewing business concepts and business plans to discuss activities that may be regulated. And of course, we want to provide assistance with navigating the licensing or chartering process. The site also has information about fintech enforcement and has a page for consumers. So this is a work in progress, our Center for Fintech Information. Our goal here is communication with industry. We want to assist you in understanding Washington's regulatory structure as it applies to your business interests. We're not interested in gotcha enforcement. We are interested in Washington consumers having many safe financial services options. And we're interested in Washington being at the forefront of financial services innovation. With that, I'll wrap up. I hope you enjoy the discussion today and find it informative. I will have to drop off the last 45 minutes of the call for another engagement, but we have many on the call who can field your questions that you may have. Thank you.
Good morning.
Cindy, we actually are going to have the WTIA blockchain presentation first, and then we'll kick it over to DFI.
Of course you are. I'm so sorry.
No
Thank
worries.
you.
So, Ari, perfect.
Yeah, I'm sure Sydney's just really excited to share all that she and the team's been doing with the DFI. So really appreciate the excitement. And thank you, Charlie, for sharing your updates about the DFI. Thank you for announcing the Center for Fintech Information. I'm really, really excited to hear that and really, really appreciate all the hard work that it took to get that launched so quickly. And we look forward to working with you more in making sure that the community knows how to engage with it, knows how to engage with the DFI, and we can look for ways to just continually, iteratively up our game together in making this one of the best places to work and live and innovate and grow together. Let me share my screen. Molly, will you be joining? Molly is the VP of Government Affairs with the WTIA and has been instrumental in helping us take a lot of the work that the Cascadia Blockchain Council has done with the WTIA on the policy front, and has just been super amazing since she's joined the team. Let's see, sharing screen.
Great, thanks, Ari, and thank you everyone for being here today. I can't see you because we're on Zoom, but really do appreciate the strong attendance I see in the chat. Thank you as well to DFI. The whole team behind the scenes has done a tremendous amount of work preparing for this day. And Charlie, those opening remarks were really exciting, and really pleased to see the launch of the Center for Fintech Information. I'm looking forward to working more with that office. I'm going to start, Ari, if we can go to the next slide. Just outlining a few high-level goals for the town hall today. You know, we're excited to use this platform to increase the blockchain community's understanding of DFI's operations and resources available to support the blockchain industry and community here in Washington. We're excited to meet the DFI team and create new points of connectivity and awareness for the blockchain community. We're also here to relay concerns and challenges faced by our member companies in the state, and then during that discussion, hope to identify opportunities for solutions and partnership. Next slide. So I want us to set the stage on Washington's digital asset landscape before we get started today. Washington, as everyone has mentioned so far in the call, is a vibrant hub for tech innovation. We've made tremendous progress in enabling digital asset companies to exist in the state, and the state has also taken the lead on several national initiatives, such as the multi-state licensing initiative. However, you know, the regulatory environments in other states are kind of outpacing Washington in some areas, and we've seen some founders and investors skip over Washington and form in other states. You know, I think we all share the same goal, that we want Washington to be the place where people kind of grow and found their business. You know, many startups and popular exchanges want to be compliant, but do face challenges understanding how to do that. And, you know, I think we all believe that policy landscape is critical to kind of attracting that innovation while also promoting consumer protection. Next slide. So a bit about the Cascadia Blockchain Council. I know many of you are members here, and thank you so much for joining. We were founded in 2018 to serve as the subject matter experts and collective voice to advocate for constructive policies and educate stakeholders in Washington and at the national level. We have over 390 leaders engaged in our council, and we're really grateful for everyone's kind of active input and participation that helps us kind of inform these recommendations that we're making today. And then, you know, next slide, just one final point before turning it over to Ari is really to underscore that this policy landscape is really critical to enable innovation in Washington. And it's not just Washington that's facing this challenge. You know, I think when you look at tech regulation in any sector, the innovation is often happening faster than the policy. And so, you know, we're here today to try to help communicate some of those advances so that policy can keep pace. And across the country, you know, there is a lack of consistency with respect to how businesses that deal in digital assets are treated in various states and at the federal level. You know, some guidance issued at the federal level is not mirrored in states in the same ways. But we do see the opportunity in states like Wyoming who've seen tremendous job creation and growth in the sector if the policy environment and incentives are structured in the right way. And again, you know, it's those two dual needs of protecting consumers and promoting innovation. And so thank you all for being here. I'm going to turn it over to Ari now to walk through some specific recommendations we've developed with our member companies. Thank you.
Thank you, Molly. Let's see. All right, so we'll be presenting a few recommendations that we've put together by consolidating feedback from various members of the community. Not just the innovators, but also investors are very, very actively vocal and wanting to invest in this sector, pull together and invest and help companies set up and their offices here in Washington. And so this is a consolidation of lots of different feedback that we've heard from the community. And if you have, I guess, points of views that haven't been captured, feel free to reach out to us at any time, because we want to make sure that you're heard and that we're creating a proactive vehicle and medium for you to be able to figure out how to address those concerns or issues, or maybe it's a conversation with a service provider or with a regulator. And so we just want to be helpful to the community as much as possible. So one thing that we've heard over and over again is around this idea of what are these definitions and what are these official definitions that make up this digital asset and blockchain world. And definitions of like, what's a token? What kind of tokens are there? Am I an exchange or am I not an exchange? What's a cryptocurrency? What's a regulated cryptocurrency? What's a stable coin? What's a wallet? We do know that there are definitions that have been posted on the DFI site, and we have learned that there are, definitions also FinCEN have provided. But with the community, it's because I'm an entrepreneur myself, we still struggle with how to move forward with the definitions that are out there and how to navigate it and how to even find them. And so I think with the Center of Fintech Information, this might be made easier. So I'm really excited to check it out. But anything that you can do as regulators to help the community just without too much effort and too much brain power, or having to seek out a lawyer to figure out what these definitions are and what fits or doesn't fits, would be really, really helpful. And even if the DFI had in big bold statements, letters saying like, we also follow and are on the same page with the FinCEN guidance in terms of these definitions, that would also help innovators working with their service providers be able to figure out what is the actual definition and where does it land. I think a lot of effort is being spent trying to figure out where are these definitions and the little minutia of words. And if there's any ways that we can fast track that and make it just plain, simple English, that would be very much appreciated. And as I mentioned before, there's a lot of challenges around how do I navigate the space? How do I come into the space? How do I build in the space without it costing a lot of money in terms of legal fees? And by a lot of money, we're looking upwards of $500 to $1 million in the first couple of years, year alone, in setting up as a new entity in this digital asset world. And a lot of people will be like, oh my goodness, how is that possible? And I think one thing to really understand is that maybe it's the PTSD that comes out of having gone through the 2017, 18, 19 era. But there's a lot of fear for those that are working in the digital asset world of just being subpoenaed, or we're afraid of regulators. And so I know from talking to the DFI that the DFI really does want to have an open relationship with the community. And so I think one of the ways that we can get there is whatever that the DFI can provide, and perhaps it's the Center for Fintech Information, providing clear guidance for an entrepreneur to be able to set up shop and innovate with different technologies or ideas or business models, following a 5-step process, or having a template, a series of templates that they can follow with good intention. And entrepreneurs, we're going to get things wrong, not by any intention, but we're trying different things. And so if there's easier ways for us to be able to figure out how to register and how to get a license, and do I even need a license, and can I just do a trial license without having to have a team of lawyers do an analysis end to end of my entire business model, which may change in the next few months as an entrepreneur. So it's really important that we figure out how to create more streamlined processes, just like the DFI did with the money transmission process with the 33 states. We'd look for your help in guidance in figuring out how do we create something like that for an entrepreneur to set up a new investment vehicle to invest in blockchain and cryptocurrency startups, or a startup to tokenize their loyalty points and create a cryptocurrency out of it. How do they do that very quickly without all the legal overhead to start? Because the faster that where innovators can set up and create businesses, the faster that they can iterate through all the different variables of what makes a business stand up and be truly hardened and mature to being able to raise funds. So I think this will be an ongoing conversation, but it also will be just different parts of the community, whether it's on the innovator side or with the Center for Fintech Information. Someone needs to put together a straw man and help us with these fast-tracked templates for entrepreneurs to take and run with. Increased information and transparency shared by the DFI with the business community. And I really appreciate, Charlie, that you recognize that we do want a lot more communication. I mean, this industry and this community, we're hyper communicative. We're on Twitter, crypto Twitter is a thing. We're on Discord, we're in Slack, we're in Telegram, we're on Reddit. We're hyper communicative. And so this community really needs much more communication. Otherwise, what ends up happening is, and what's ended up happening is that we end up working in two silos unintentionally. And the community doesn't realize that the DFI has been doing all this work and innovation and trying to make this better for the community and so what we really need is, more easily accessible folks. So I think the Center for Fintech Information with the proper staff will help quite a bit. Being able to call somebody instead of just an unknown phone number. As an innovator, you wonder, well, am I going to call the right person? Am I going to call the wrong person who might end up sending the regulators after me? Is this a safe place? Is this not a safe place? And so having a human touch to it is really, really important to us. And remember, in the blockchain and crypto community, the idea of transparency and visibility is really, really important. It's one of our core values in this industry. And so we hope that the DFI will also embrace that as one of the core values when engaging with the community. The idea of public and private partnerships is also really important. Us innovators, we're in the trenches day in and day out, trying out different things. And we've already seen it with DeFi, decentralized finance. Since the middle of last year, 2020, over the last 9-10 months, it's blown up. So many things have changed, so many different players, so many different innovations, and that'll continue. And so the more we can partner and create these information exchanges and also help the DFI know about all the different nuances of working in this new business model and this new landscape and with this new technology, I think we'll be able to help each other innovate while also keeping people safe. And then so navigating the website, the DFI website, has been really, really challenging for us in the community. And so I think it's great that there's going to be a Center for Fintech Information. Again, like, this community really values high touch, high communication. And so, if there's ways to create videos, to humanize the DFI, to create easy to follow 5-step process to figure out if you need a license or not, or to figure out if your definition fits or doesn't fit, or guidance on or list of related companies in a particular using cryptocurrencies. Anything that we could do to make it easier for an entrepreneur to point somewhere and be able to figure out where are the lines and how to build this in a safe way. And then we'd also like, I think that announcement about having 4 new guidance being published in the Center for Fintech Information is really, really helpful too, because the community, again, we need more communication. And so any interpretive letters, decisions or statements, I know that there has to be privacy of companies kept, but if there are any lessons learned that you can share with the community so that we can also learn as the DFI learns along the space, and we can work side to side, shoulder to shoulder, that's also something that the community would like more of. Creating alignment with national regulators. I think I just heard Charlie speak to this, and what I heard was that the DFI does spend quite a bit of time and resources working with the national regulators. So that's really great to hear, but we don't know what that means. And we haven't heard about it until very recently today. So if there's more guidance or clarity or webinars or statements that the DFI can provide to help the community understand the DFI's position when it comes to how the regulators are working versus the DFI, how versus the SEC versus FinCEN, that would be really, really helpful. Then we won't have to each employ lawyers to go and figure out the national versus the state alignment. I think this can be done at the state level. So since you're already doing it, please help us understand your point of view and your position around this. We've heard there's a little bit of incongruity between what the Howey test is versus how Washington State defines its security. And so having clarity around that would be really helpful. Like I mentioned before, the investor community is really, really active in this space. And so investors want to invest in innovative companies, and the investors want to take part of all the different kinds of financial products that are being made available through this industry. And so recommendations or ideas or suggestions or easy ways for us to work together to allow more money to come into the state, to allow for more innovation and more jobs to be created, and the future Jeff Bezos or the future Bill Gates, Microsofts to be created. This is where and when it's happening right now. And then I think this is the final thought. So advancing innovative technologies. The space is changing so quickly. I've been studying it for many years. I even taught a boot camp, and even then I struggled to stay on top of all the innovation that's happening. And so I think this has to be a community approach. We have to teach each other. We have to share our notes. We can't be working in our silos and our different projects. We have to look up and share proactively so that we can grow together. And so let's see, I think one of the things that I've heard very often from members in the community is we're not trying to be bad. We're not trying to skirt the law. We're not trying to, make a couple more dollars by, cutting corners. We just don't know. So if there's ways for companies to be, if companies are found to be out of compliance, is there a way for them to, or us to be able to say like, hey, this was out of good intention. What can we do to fix this and get back right on track? And not have it be a frightening experience. Because that frightened entrepreneur will go and tell other folks to be frightened, and the word gets out, and this is the state of things right now. We need this region to be known as a safe and flexible and fun and supportive environment for innovators to try new things, because if you're afraid, we're not going to be pushing the boundaries on innovation and coming up with new ways to help humanity do things better and faster and more efficiently. a lot of the innovation comes from investment dollars. So, Silicon Valley has traditionally been known as the place to raise money, but I think there's a lot of opportunity. We have a lot of wealth that's been created here in this region. And so if we can figure out ways to make that wealth accessible to innovators, then we'll have the circle of life of innovation and capital available for innovators to hire more and innovate faster and be very competitive in this very, very competitive industry. And then along with the public and private partnerships, we've heard that the DFI does spend quite a bit on resources to educate their staff and continuing education pieces, but we as innovators, again, we're in the trenches. And so if there's things that we could do to create proactive education from those in the trenches, where community members can come together and say like, hey, DFI, we'd love to give you all the latest on NFTs. And we have several players in Washington State that are working on these different arenas. And we'd love to be able to present to you and allow you to ask questions and learn about the space. We'd love to be able to create those, to create opportunities for not just the community to learn and to come together, but for the DFI staff to learn and stay on the cutting edge of this innovative environment. And then, we'd love to continue to partner on legislative agendas. We have lots of ideas of things that we would like to make better and faster. We're building partnerships with other states, just as the DFI is. And so I think the more we can come together and collaborate, because we all have the same goals and desires, I think that'll help us all build together and rise together. So that's it for my spiel, for the DFI and also for those in the community. If you have any questions, if you have any feedback, if there's anything that was not mentioned from your concerns, please do let us know. For the DFI, what we really want as innovators is templates, one-pagers, how to set up a fund, how to set up a new cryptocurrency in a box. These 5-step processes as much as possible. And, we'd love to partner with you in creating those. We have lots of ideas that we've been working on as the Blockchain Council. And so there's ways that we can bring these to you as proposals and figure out ways how to make them better and then release them to the community. That's something that we would very much like the opportunity to do. I think with that, are we on time?
Thanks, Ari. Yeah.
Reason the order of speakers. So let me back up a little bit. I'm Cindy Fazio. I am the Director of Consumer Services, and that is kind of the non-depository side of our house. And that's where anything non-securities and non-bank or credit union, that's where we regulate things. And specifically, the state has a statute called the Uniform Money Services Act. And that is the statute that regulates money services businesses, specifically money transmitters. And all of this is very important because it is there that we first began regulating virtual currencies. And so the order of the speakers is very important because we also are an embodiment of the evolution of the underlying distributed ledger technology, right? So the very first thing that happened with the distributed ledger technology is a digital currency platform was put on top of it. And as we know, that digital currency was Bitcoin, right? And so right out of the box, we had FinCEN's guidance, which here at DFI, after the group that Charlie spoke about, after a group had been looking at it, receiving inquiries about it, thinking about it for almost a year, we said, well, that's the federal regulator in the space. We may not necessarily agree 100% with them not calling it money or not defining it as a currency, but we're going to use that basic rubric of regulation. So our very first output to the community was our guidance, and our guidance largely followed that FinCEN guidance. So that was the initial wave, if you will, of virtual currencies into this space. So let me talk for just a minute back to the evolution. So a lot of the way I learn is by charts and graphs. And so I was looking at the names of the presenters and I was going through it. And do you know that on our tax returns for 2020, the IRS finally went in and amended their guidance language, which had always been property, right? Virtual currencies are properties. Their guidance specifically went in and talked about virtual currency and how to report it. And that was just a very exciting moment to me. I usually don't get excited doing my taxes, but I have to say this was exciting, and I want to read you the language. So the IRS has been talking about property, virtual currency as property, since about 2014. And then this year, the language, let me get over to it here. The language. Sorry, my mouse is very touchy. Okay. Bear with me one moment. So technology is a process, right? Okay, so this year, the released Form 1040 has the question right below the taxpayer's name that gives you the specifics about how to disclose virtual currency, and it's very much more specific. And so that is a very exciting thing about taxes these days. So the evolution, FinCEN came out with their guidance. We came up with our guidance. FinCEN did start to put out more guidances, talking more about who the users are, who the administrators are. So we saw all of this guidance going forward. Our very first licensee in this space, following our guidance, was a Bitcoin ATM up in Seattle. It was very, very exciting. A number of us went up there. We watched it work. It was very exciting. And at the time, it wasn't the day job of the person. This was their hobby, right? Okay, so now our guidance has been out there for a while, and we have been getting a number of licensees, ATMs, other methods of business models that fit within the statute. So we're licensing folks, we're continuing to see guidance where the SEC was kind of notably the last to come out with some guidance, right? And I remember being really happy when the SEC came out with some guidance, because we had started seeing some of the threads between virtual currencies and securities. And we had started talking with our Securities Division, and Ari, I really appreciated your comments about silos, because we were pretty used to being in a silo with money transmission. And so now we were having to talk with our counterparts in securities, and that turned out to be a great thing. And that was very good. So after the guidance was out there, we then went back to our statute and needed to needed to amend the statute to provide additional clarification. So you can see that process here on this page. And I wanted to tell you that the stakeholders that were involved in that. So, you know, at DFI, we are very interactive with our stakeholders. They're the ones with the businesses. They're the ones out there providing the service. And so we are very active with our stakeholders. So we had the Chamber of Digital Commerce, we had Coin Center, we had Coinbase, we had the Electronic Transfer Association, MasterCard, the Money Services Roundtable, Fiserv, Stripe. So those were the folks that we had specific interaction with in amending our statute. Okay, so some of the business models early on were, of course, the Bitcoin ATM, and then we had the third-party money transmitters that we were licensing. Then we had Overstock.com, right? The very first retail merchant, or one of the first retail merchants that came out and said, you can pay for your goods and services with Bitcoin. And so, so what was really happening, of course, is they had a service provider on the back end that was converting that to them. So wallets, of course, became a huge part of the conversation. And so we were learning all about wallets. And not even that small piece became static, right? Because not long after we were feeling comfortable about hot wallets, cold wallets, then somebody said to me, well, what about multi-sig wallets? And so not even that piece of anything stayed static. And so again, here are some of the business models that we were able to come out and say, okay, this is not a financial service provided to consumers by another, whereby the consumer is at risk of harm, whereby there is the risk of anti-money laundering problems, and largely followed FinCEN. FinCEN was really quick about providing all those different guidances, right? So of course, the actual underlying software protocol. So by this time, by the time that we were able to make that statement about ownership or authenticity for something that is not being used as a medium of exchange or a financial service, now we're really starting, I mean, now we're setting the stage for NFTs, right? So very, very amazing. So getting back, so Charlie said, look, this licensing program is really clogging down, and we've been hearing how burdensome it is, and we really need to do something about it. So this is the original group of states who got together and said, we have got to license these companies, and now this was specific to MSBs, specific to money transmitters, specific to those money transmitters using virtual currencies in their business models. Look at this lovely lovely map. So these are the original states that started up the licensing agreement. Then we proceeded to, at the conferences that Charlie was talking about, which was pretty much twice a year. And so twice a year since 2014, we would go out to these conferences that consisted of other regulators and industry. And we would say, you need to join our program, you need to join our program, you need to join our program. So now this map shows you all of the participating states. The darker colored states are a key difference in that they are the phase 1 certifying states. So when we're putting this program together, we said we have got to have state regulators that provide the highest bar of regulation, get the innovative company licensed at that level, then the other states who don't do criminal background checks, who don't do certain financial services checks, who may not at the licensing phase do robust BSA AML checks, then they can license at the second phase. But right off the bat, we said for these companies to have the confidence of the community and the consumer community and the regulators, we've got to get them licensed at the highest bar. And that means full criminal background checks and full BSA AML. So at this time, we're starting to learn about the role of investors. I remember attending a conference at CSBS that Charlie mentioned, the Conference of State Bank Supervisors, where we had pulled together some industry representatives. And that group, that industry representative group, still exists today. It's called the Financial Industry Advisory Panel. And I remember a person standing up and saying, you're not understanding that behind us is an investor who wants to give us a lot of money to go forward with our innovation. And your licensing program is causing certain problems with our investor. So we started looking at the whole investor role as within business models. Okay, so this is just a quick showing you the phase 1 for the common elements at the high bar, the phase 2 for the state specifics. That's back to our licensing program. So as Charlie mentioned, the program, we ran several pilots. We had surveys of industry. One of the things they loved the most, and Ari, this resonates with your comments about being able to contact a person at DFI to feel like you're going in the correct direction and to feel like you don't need to be worried about getting a subpoena the next day after you've contacted a regulator. So that's that single point of contact. Then we promised industry that there would be a certain efficiency to the process. And so we started putting in time limits on ourselves. So when a state came into the process, they would have to agree to certain timelines, certain deadlines. That program, and I was thinking Ari as well, that program has a number of communications that go out to the business. We contact them when we've received their intake, when they've been assigned, when their next deadlines are, when they need to apply with all the other states. If it's taking longer than they thought to get applications, we tell them that they may be able to get an extension. And Ari, let me speak specifically. You mentioned, coming up with a business plan that may change, the next month because you're an innovative business. That has been a really significant issue that this licensing group has struggled with, because when we vet a business plan, we're vetting the product, we're vetting the people, and if that changes right away, then our vetting doesn't have value. So specifically within that licensing agreement, we noticed that among some of these innovative companies, we noticed that changing of control people, changing of the product being provided. And so that is a business model that isn't completely cooked and set and able to at least stay in its current form for a certain period of time can be problematic. So we ended up, as of the end of May, we've certified. So that means 40 companies went through the process, got certified by the 29 participating states. Right now we have 9 pending. We tend to get 1 to 3 intakes a month into our program. And look at the number of licenses that can follow. So just a ton of licenses. That's 307 since 2018. So okay. So that's the end of my presentation. And so whereas I'm speaking for some historical moments in this process, I'm speaking about the initial look by state and federal regulators. And so now we're going to evolutionarily move forward with our next speakers. So let me check this really quick. Yes, and then also the decentralized finance is very, very interesting. And we have started looking at some DeFi business models, and we're going to put them through the new Center for Fintech Information.
So my name again is Faith Anderson. I am the Chief of Registration and Regulatory Affairs for the Securities Division of the Department of Financial Institutions. And if you take nothing else away from what we say today, I hope that you do get the message that we are available and we do want to engage with the industry. In the Securities Division, we've always been available by email, well, since email was invented anyway. Phone, we have a web form contact, and we're hoping soon to be able to return to being able to provide in-person meetings. And we also make ourselves available for speaking events, whether it be to consumers, investors, or to groups of entrepreneurs that are interested in learning about the securities laws. And we do have one of our staff attorneys who will be going out next month actually to speak to a group that inquired about cryptocurrency from an investing side of things. So keep that in mind. So I wanted to share a little bit about the Securities Division before we move on to talk about the new guidance that has been published on DFI's Center for Fintech Information website. Our director is Bill Beatty. He began with the division in 1986 and has been our division director since 2010. He served as staff attorney, general counsel, and program manager in the Securities Division. So he has a lot of experience. And as Charlie mentioned, he has held various positions with NASA since very early in his career, 1990, including president, and he is currently on the NASA Board of Directors, chairs its Electronic Filing Depository Committee, and is also chair of its Federal Legislation Committee. And before I move on, I guess I need to explain what NASA is. We're not talking about the space agency. Rather, we're talking about the North American Securities Administrators Association. This is the organization of state securities regulators that has been around since 1911. And its membership consists of the securities regulators from all 50 states, DC, US Virgin Islands, Puerto Rico, all of the Canadian provinces, and Mexico. The organization facilitates contacts between those regulators, organizes training events in each regulatory area that those regulators are involved in, whether it's securities registration, investment advisor regulation, broker-dealer regulation, for example. And the organization facilitates uniformity amongst the states by promulgating statements of policy, uniform model laws, uniform model regulations. So that's a little bit about the organization and our director. We have 3 program managers in the Securities Division, myself as Chief of Registration and Regulatory Affairs. My responsibilities include overseeing all the processing of all applications for securities registration, the processing of all exemption notice filings, working on our rules, reviewing legislation, and we also administer our State Franchise Act. Over licensing and exams, we have Joanne Jones. She oversees the licensing and examination, as the title would suggest, of all state registered investment advisors, broker-dealers, security salespersons, and representatives of investment advisors. And then finally, we have Suzanne Saracen, who is our Chief of Enforcement, and she oversees all of our enforcement staff that are working on enforcement cases, whether they be administrative or partnering with criminal prosecutors on criminal securities and franchise cases. So there's quite a bit of distinction there, but if you contact me, I'm not going to automatically go run over to our enforcement section and say, this company contacted me. So understand that there's some bifurcation of responsibility there, and you can always contact, myself and Joanne to talk about issues in advance rather than corresponding with Suzanne on the back end of things. Each of these program managers has at least 20 years of experience, and that does include myself. And we're actively involved in NASA as well. I am on NASA's Corporation Finance Section Committee. I chair the Small Business Project Group. I am on the EFD committee, which is a nationwide filing system. And I'm also on the State Legislation Committee. Joanne Jones and Suzanne Saracen are also involved with various investment advisor project groups. We have a total staff in the Securities Division of 47 people, and that includes 21 attorneys. In DFI, we have more than 40 attorneys, which is a reason why we actually operate an in-house CLE program for our attorneys to ensure that they're receiving ongoing training and that they are able to meet their continuing legal education requirements with the bar. We invite in expert speakers on various subjects to provide that training. And it's not just our director or our program managers that are actively involved in NASA, but actually among our staff, we have 21 staff members that have received 36 appointments on 30 committees or project groups within NASA. This is really probably one of the highest levels of state involvement within that organization amongst the states. 8 of our staff members were appointed to chair, co-chair, or vice chair position on 9 of those committees and project groups. In all, we have representation in all 5 NASA sections and on 10 board level committees. We also engage with our federal counterparts, including the SEC and FINRA, through NASA, and also our staff have developed personal contacts with individuals within those organizations. And it's in all areas, including registration, licensing, exams, and enforcement. Our mission in the Securities Division is to protect the investing public and promote confidence in the capital markets. And I think it's always important to keep in mind that this is a statute that is remedial in nature and replaces the principle of caveat emptor, otherwise known as buyer beware. That principle is replaced with burdens that are placed on those that are selling securities in order to protect investors. With that, I'll move along to talk about our new cryptocurrency guidance. We have included a special section on the CFI website to provide guidance with respect to the securities laws in Washington and how they might apply to digital asset securities. The guidance discusses the Washington definition of security and how it fits with federal law. And I note here that there are very little differences between the federal definition of security and the state definition of security. And both the federal definition and the state definition include investment contracts. And Washington courts follow the federal court's interpretation of what an investment contract is, and specifically that Howey test and its progeny. The guidance includes some summaries of federal guidance that has been published by the SEC. And the reason that we do that is because we generally follow that guidance, given the similarity in our definition as compared to the federal definition. The guidance includes, the summaries include a summary of the Dow report from 2017, as well as the SEC's 2019 framework for the investment contract analysis of digital assets. It includes references to the SEC statements by both the former director of corporation finance, Will Hinman, and the former chair of the SEC, Jay Clayton, on Bitcoin, Ethereum, that they acknowledge that those are not securities. The guidance that we published also includes a discussion of utility tokens and references the 3 no action letters that have been issued by the SEC concerning those types of tokens. And if you're familiar with those, they include turnkey jet, pocket full of quarters, and IMVU. In those no action letters, the SEC noted in particular that those tokens were sold for consumptive purposes, not speculation, that they were immediately usable, and that the platforms had already been developed. Our guidance goes further to note that trading in digital asset securities may raise broker-dealer and investment advisor registration issues. So if what you are planning to do involves a token, one of the basic requirements under both federal and state law, but I'm focusing here on state law, is that the token offering must be either registered or exempt, or it must be made under a federal exemption from registration that carries with it preemption of state law. And those are referred to as federal covered securities. With respect to tokens and other digital asset securities, most of them have been made, these offerings have been made under Rule 506B and Rule 506C. These are federal exemptions from registration. And it's important to discuss those, but also to note that state law is preempted with respect to offerings that are made under Rule 506B and 506C, meaning we can't impose any substantive requirements on those types of offerings. The only thing that we can do is require a perfunctory notice filing, and we also maintain our anti-fraud authority over those types of offerings. These offerings are under Rule 506B and 506C. These are offerings that are made primarily to accredited investors, and that is a term that is defined under federal law. Washington has not adopted a separate definition of accredited investor, and with respect to Rule 506B and Rule 506C, it wouldn't even matter if we had adopted a separate definition because of the fact that federal law preempts us with respect to those types of offerings. Other possible exemptions that someone doing a token offering might use include Reg CF, which is the federal crowdfunding rules, and Reg A Tier 2, which has been referred to as a mini IPO. Under Reg CF, you can sell up to $5 million of securities in a 12-month period, and under Tier 2, you can sell up to $75 million in a 12-month period. These are exemptions that are not limited to accredited investors, so average ordinary investors can invest in those types of offerings. And again, these are exemptions that carry with them the benefit of preemption of state law. So Washington does not impose any substantive requirements on offerings that are made under Reg CF or Reg A Tier 2. The only thing that we do require is a perfunctory notice filing. And so beyond these exemptions, if an exemption is not available to the offering because it cannot otherwise comply with the terms of the federal rules, then the offering would need to generally be registered under federal law and under state law. And we have had one token offering that was registered at the federal level, and it was also registered with the state of Washington. They became registered last summer in August. That was an offering that was registered by coordination in Washington. And what that means is that the documents that they were using federally to register and to make the offering to investors were the same documents that they used to register in Washington. And their effective date for their registration was coordinated in Washington with the effective date federally. So we understand that these navigating these exemptions and how to register an offering can be intimidating to someone that doesn't have a background in securities laws. And for that reason, we do very much so try to make ourselves available through email, phone calls, speaking events, in-person meetings. We've done it all really to help entrepreneurs to understand these laws better and figure out how they might do an offering that will comply with the law, whether it's a token offering or a more traditional securities offering. We do not require anybody that approaches us that way to be represented by counsel, and we do often receive inquiries from people that are not represented by counsel. And while we cannot give legal or financial advice, we very much so can provide information about our laws and how they coordinate with federal law. We also have information published on our website that's geared towards entrepreneurs and discusses these exemptions and the registration requirements. And we also publish all of our interpretive and policy statements on our website. So beyond the registration and exemption requirement, licensing requirements may arise. Our licensing staff is also available by email and phone. They also conduct what they refer to as pre-licensing meetings. Once an application has been received by our licensing staff, they will complete a thorough review of the application. They look at all the documents, they look for disciplinary history involving the individuals, they look at the financial condition of the firm, and they work with the applicants prior to approving that licensing application. It's not as if you file an application and we either deny it or approve it. It's more of a collaborative process where we work through the issues with the filers to bring them into compliance with the law, and in some cases to educate them on what the requirements are. With respect to advisors to private funds, the review will include looking through their private placement memorandums, their LLC or limited partnership agreements, and any other relevant agreements. And as I said, the point is to bring them into compliance. At the federal level, this level of service does not occur until after the applicant has become licensed and the SEC has gone out to examine the investment advisor. And in that situation, then they find out that they're not in compliance and may have an enforcement issue. And we think it's a much better service to both the firms and the individuals that we regulate and to the public to ensure compliance up front rather than on the back end. So after an applicant has become licensed, and particularly with respect to investment advisors, our examination staff will perform a technical assistance visit with that licensee within 12 months of them becoming licensed. And this is another opportunity for the licensee to learn and to come into compliance without a formal examination taking place. And I want to make a special note here about advisors to 3C1 funds. These are funds that are limited to 100 investors and are exempt federally under the Investment Company Act, and their advisors are required to register at the state level in Washington. We have a private fund advisor exemption, but as was noted earlier, that exemption does not extend to advisors to 3C1 funds. This was a very deliberate policy decision based on our long history of regulating these types of advisors and knowing the issues that we see on examination and in enforcement. And I think it's important to keep in mind here that these are advisors that, they don't have to meet any education or experience requirements to become licensed. They are often solo business operations, and they often manage the entire investment portfolio of their clients. And furthermore, they're not, these are advisors that are registering at the state level. They're not registered with the SEC. So we continue to believe that it is necessary to license and examine these advisors to ensure a base level of investor protection for those that are investing with these advisors in our state. So now I'll move along to enforcement. Probably not everybody's favorite topic, but I want to point out here at the outset that none of the enforcement actions that we have brought that involve digital asset securities were brought solely on that risk capital test that some have noted is a difference between state and federal law. In each one of our enforcement cases that involved tokens or other digital assets, the offering also satisfied the investment contract test as first established in Howey. But unfortunately, in those cases, those issuers and the people that were involved with this offering did not come to our offices. They did not contact our staff to ask, what they needed to do to comply with the securities laws. And we really wish that they would have, because we would have advised them as to, what we believed was appropriate from a regulatory standpoint. I also want to note on the enforcement front that an issuer or people that are cooperating with our investigations, that cooperation is taken into account when we're considering what type of enforcement action to take, whether it be looking for a consent order or going straight out with a statement of charges to try to order the issuer to cease and desist from violating our acts. We have authority to bar individuals from being involved in a securities offering. We have the authority to bar issuers from using certain exemptions under our Securities Act. These are more severe actions that we can take. So we do have options and discretion as to the type of action that we take. And we also have discretion in determining the amount of fines that we impose. And of course, cooperation is taken into account in both of those calculations. And then finally, on the enforcement front, we do publish all of our enforcement actions on our website, and we have done so for a very, very long time. But as part of the Center for fintech information, we have grouped those enforcement actions that involve tokens or other digital assets into one place. So you can see those orders and take a look at them for yourself. There have been 9 of them since 2019, which isn't much when you look at, the fact that the SEC has taken 75 actions to date. But I don't want to leave you with that. Again, I want to, emphasize that we are available for your questions. We want to engage with you, and that we are optimistic that our new Center for FinTech Information will provide additional guidance that can help issuers and others that are involved in this industry to know how to contact us, to understand the laws better, and that by providing this information that we can hopefully see fewer enforcement actions in the future. So with that, I will turn it over to Roberta Hollingshead, our Director of Banks.
All right, thanks, Callie. Appreciate that. Well, good morning. I'm Roberta Hollingshead, Director of Banks Director of Banks in the Division of Banks. So in my division, we oversee all the state chartered banks in addition to the non-depository trust companies. And so in the banking and non-depository trust space, the safekeeping or custody of digital assets is really the most prominent emerging business model. So that's what I'm going to talk about today. And in Washington DFI, we really believe that these types of business models will largely fit into our existing trust charter, which is RCW 30B. We have updated and modernized these statutes in 2014 and then again in 2019 to ensure that the custody of digital assets is a permissible power for a non-depository trust company headquartered in our state and headquartered in other states but operating in our state. So this morning, I'm going to cover some of what's happening. I can't cover it all, certainly. Some of what's happening at the state and federal level, and then I'll circle back to talk about Washington DFI's stance on banks and trust companies providing services to digital asset companies. And then, real briefly, Charlie mentioned Conference of State Bank Supervisors. I am also really involved with Conference of State Bank Supervisors. I serve as the District 5 chair, which includes all of the Western states, including Wyoming. So I've got great contacts in Wyoming and have definitely, been up to speed on what they've been up to over there in this space. We also meet, the board of CSBS meets 4 times formally a year with our state counterparts. And we also meet in our region twice a year with our federal counterparts. So that would include the FDIC, the Federal Reserve, Office of Comptroller Currency, the OCC, CFPB, National Credit Union Associations come sometimes, as well as, who did I miss? Maybe I covered them all the acronyms there. So just wanted you to be aware, we are, in my division, several of my staff members also sit on committees at CSBS and are very active in that association as well. So we've got great state and federal contacts in this space. I'm going to talk through a little bit about what's going on at the national level as well. So first I'll start with sort of the origin and evolution of us getting involved with crypto asset custody. Our first direct encounter was with Gemini Trust Company, which was chartered in 2014 and regulated by the state of New York DFS, under a special purpose trust charter. So Gemini applied to us to operate as a trust charter in Washington. And you may not know, but a majority of the states have signed on to what is called the non-depository trust multi-state agreement. And the purpose of this agreement is to recognize a non-depository trust company that's headquartered in another state and allow them to operate in your state. Now, sometimes you will have to take a look at specific state requirements for the trust company to operate, but it shouldn't require another charter or a license so long as it meets the definition of that agreement. So in Washington DFI, we worked with the state of New York and the company. We followed this multi-state agreement. We did require some changes to Gemini's consumer disclosure, but we worked through that and they began operating as a trust company in Washington. At that time, And still to this day, unfortunately, many states didn't recognize Gemini as a trust company, but instead recognized them as a money transmitter. And so, that was really our first encounter with digital asset custody, was way back in 2014. I have been with the division since 2001, so I've been around through this whole evolution, and I've certainly kept pace with what's happening. And I will mention that several other states besides Washington have non-depository trust companies that offer digital asset custody. I'm not going to go over all of those states, but it was really New York that first brought this to our attention. More recently, as was sort of mentioned earlier in the morning, Wyoming, the legislature and the government, they really embraced digital asset legislation. In the banking space, they created a new bank charter called the Special Purpose Depository Institution. I'm sure you're all familiar with that. We refer to those as speedy banks. They've chartered 2 banks and they have several more in the pipeline. And these banks primarily provide the safekeeping and custody of digital assets for institutional investors, although many have plans to provide these services on a retail basis as well. And some also have trading and lending of digital assets with, again, the primary function being custody. So these speedies really differ from most traditional banks because their deposits are not FDIC insured. And there's kind of some significance there. I'll get to that. And as well, currently these speedies don't have what we consider have direct access to the Federal Reserve's payment system, meaning, that they can settle fiat currency dollars in their bank at the end of the day. They have applied to they're members of the Kansas City Federal Reserve. They've applied for direct access. We know the Board of the Federal Reserve is discussing this, but at this stage, they don't have direct access to the payment system. So it's important to note, with the absence of FDIC insurance, some states will not recognize speedies as a bank because laws in their state require any bank that operates in their state to have FDIC insurance. We've reviewed our laws, and there is no requirement for an out-of-state bank to have FDIC insurance in order to operate in Washington. And thus, once we have, not formally but informally been talking to Wyoming, and once those companies reach out to us, they will be able to offer those services in our state. And it's important to know, and I'll talk about this a little bit further on when I circle back to what we're doing, but we have researched a special purpose banking charter. However, there are some statutory issues with that, with our Washington State Constitution. I'll address those in just a minute. At a national level, it's really the Office of the Comptroller of the Currency has been really out front with regard to digital assets in the banking space. They've opined that a national bank may provide crypto custody services on behalf of customers. National banks may provide permissible banking service to any lawful business they choose, as long as they can effectively manage risks and comply with laws. And that providing these custody services, including holding that unique cryptographic key, is a modern form of traditional banking activities related to custody services. The OCC has, they obviously, as we know, they have a couple charters. Some of these companies may be eligible for a national bank charter, a special purpose national bank, SPNB, all the acronyms. Provided again that they meet the chartering requirements applicable to any national bank. So there are pretty high capital requirements and liquidity requirements. Again, it's not anticipated that these special purpose national banks would have FDIC insurance, similar to Wyoming, and they may or may not gain access to the Federal Reserve's payment system. Many of you may follow what's happening at the national level and know that the OCC is currently being sued by the Conference of State Bank Supervisors in relation to their special purpose national bank charter, really just saying these, are not truly banks and they don't meet the legal definition of what the OCC has authority to charter. More recently, we've started seeing the OCC use their for digital asset custody. They've started to use their national bank, national trust bank charter. for these digital companies to engage in business. This specific charter is currently not being challenged. It's really just utilizing their traditional trust application for digital or crypto asset custody. And then, we've learned firsthand that the OCC, licensing department of the OCC, is really proactively reaching out to trust companies that provide crypto asset custody in other states who may fit into this charter. So they're really seeking out those companies, to operate under that charter. And a little bit, just briefly back to the FDIC. So, the FDIC has really not taken a position formally on digital asset custody or digital asset in the insured banking space. It is important to remember that the FDIC is an insurer. They are a supervisor of banks. We work closely with the FDIC in supervision of our banks, but they're not a chartering agency. The OCC and the states are the chartering agency. The FDIC is the insurer and they're the receiver if a bank fails. So we are in active dialogue with the FDIC. And the way that law works is the FDIC essentially says, from their perspective, they don't establish powers for banks. That's up to the chartering authority. But they've come out and they've said that they're, researching and looking into digital assets as far as if a bank were to custody digital assets and be FDIC insured. If that bank fails, they would take in those assets as the receiver. So they're certainly very engaged and involved in the dialogue. But unless the FDIC were to come out and specifically say that the custody of digital assets is an unsafe and unsound practice, which, I don't think they would go that direction, but that's really the only way that they could prevent an existing bank chartered under the OCC or under a state that again has FDIC insurance already. That's really the only way that they could get involved in whether or not a bank could have digital asset custody. They'd have to say it's unsafe and unsound. And I don't anticipate that that's the position that they're going to take. But again, we really haven't heard much from them on this topic. So now I'll talk about Washington law. As I mentioned, we believe that businesses whose primary function is custody of digital assets, that going through our trust charter is the correct charter. And so I'm sure you're asking, why not what Wyoming is doing? Why not a special purpose charter in Washington? So we have over the years done really extensive legal research. And one of the most salient sort of prohibiting factors for us is this Amendment 16 to the Washington State Constitution. This was passed in 1940. It was a voter approved amendment to the Constitution. And it essentially says that a bank that is organized in our state, so under Washington state law, has to have FDIC insurance, or the contracts, debts, and obligations of the bank are a liability to the shareholders of that bank. As we've discussed, at this point, these banks don't have FDIC insurance. So we feel that operating as a bank in our state is a huge obstacle for the founders to overcome. Having all that liability seems to be, obviously not optimal. In addition, we really have extensive hands-on experience with the trust charter for these digital asset custody functions. We've been working closely with Protego Trust Company. They are still currently a Washington State chartered trust company. They're not yet operating, but they're focused on digital asset custody and trading. They're still building out their infrastructure. We've been working with the company for a number of years as their business model has really continued to evolve. It looks very similar to a Wyoming Speedy. We worked very closely with the company as they developed out their infrastructure and they built their, really very sophisticated team. We've learned this alongside with them. Through that process, we've followed everything that's happening in the digital asset custody space very closely. We've worked side by side with states like Wyoming. I have a great relationship with my counterparts in Wyoming to really ensure that the regulatory requirements and challenges were, on par with what's happening in those other states. Even though it is a different charter, it's still essentially, the same functionality. We've also continued over the years to advocate for more streamlined regulation across the state system. That continues to be really a big challenge, to be quite honest, with chartering at the state level. And really, despite our efforts and ongoing relationship with the founders of Protego, the OCC recently came knocking at their door, and they are considering converting to a national bank charter, a national trust bank charter. You know, and just to kind of take a step back, the largest challenge that all these state entities have, going all the way back to Gemini Trust Company, and the Speedies may run into some challenges too, is that you know, it's still not clear for them to be able to operate on a national level. We are in the depository space, non-depository space, as you've heard, we're continuing to dialogue with our other states about this. And we do believe we are making a lot of progress setting up some model state laws that states can adopt. You know, we are lucky in our state to have a really great relationship with our legislators in order to change those laws, but not all states have those kinds of relationships. And so it makes it a little bit more challenging for states to change their existing laws to allow these businesses to operate and even to modernize their law to keep up with the times. So we're making a lot of efforts and inroads, but it continues to be a bit of a challenge with the state system. So moving along here, we have also, this is something we're issuing today on our new website. We've researched the permissibility of our existing trust companies and banks to provide these services to digital asset companies. We do believe that it is permissible for a state chartered bank or trust company to provide digital asset custody services, you know, either directly, assuming that they can manage the risk. Obviously, the risk is much different than the custody of other types of assets. So as long as they can, you know, manage that risk, we do feel that existing trust companies and banks can provide those digital asset custody services or partner with firms to be able to do that. And so today on our CFI website, we are issuing a statement, Charlie mentioned it, talking about the permissibility of custody of digital assets by existing state chartered banks and trust companies, and hopefully, you know, future entities that may want to charter in our state. Oh, I don't have a conclusion slide. So with that, that ends my presentation. I just want to reiterate what has been said previously. You know, Ari's comments were not, we've heard them before. We know regulators can be intimidating. You know, we kind of forget that because we don't take ourselves that seriously. And Ari, I have been told before I'm pretty nice for a regulator. So you're not the first person to say that, but we're here, we're accessible. All the members of my team are available and accessible. We want to foster innovation and we want to hear what's going on. It is hard to keep up on all the innovation. So appreciate everyone's time this morning. And with that, Kelly, I guess I'll turn it back to you. Let me get out of here.
Great. Thank you so much.